We now come to the next statement. I call the Secretary of State for Northern Ireland, Hilary Benn.
With permission, Mr. Speaker, I would like to make a statement about the death of Patrick Finucane. Patrick Finucane was a human rights lawyer. On the 12th of February 1989, he was brutally murdered in his home in North Belfast by loyalist paramilitary group the Ulster Defence Association in front of his wife Geraldine, who was wounded, and his 3 children, one of whom is now the Honourable Member for Belfast North. From that day onwards, Mrs. Finucane and her family have campaigned tirelessly in search of answers about the killing of their loved one. In 1990, an inquest was opened and closed on the same day with an open verdict. Subsequently, a number of investigations and reviews were conducted. In 2001, following the collapse of power sharing, the UK and Irish governments agreed at Weston Park to establish public inquiries into a number of Troubles-related cases if recommended by an international judge. Judge Peter Corey was appointed to conduct a review of each case, and in 2004 he recommended that the UK government hold public inquiries into 4 deaths, those of Rosemary Nelson, Robert Hamill, Billy Wright and Patrick Finucane. Judge Corey also recommended that the Irish government establish a tribunal of inquiry into the deaths of former RUC officers Bob Buchanan and Harry Breen. Inquiries were promptly established in all of these cases, with one exception: the death of Mr. Finucane. Meanwhile, in 2003, the 3rd investigation by Sir John Stevens into alleged collusion between the security forces and loyalist paramilitaries had concluded that there had been state collusion in Mr. Finucane's killing. That investigation was followed by the conviction in 2004 of one of those responsible, Ken Barrett. With criminal proceedings concluded, the then Northern Ireland Secretary, Paul Murphy, made a statement to Parliament setting out the government's commitment to establish an inquiry. But despite a number of attempts, the government was unable to reach agreement with the Finucane family on arrangements for one. In 2011, the coalition government decided against an inquiry. Instead, a review of what had happened, led by Sir Desmond de Silva QC, was established. Sir Desmond concluded that he was left, and I quote, "in no doubt that agents of the state were involved in carrying out serious violations of human rights up to and including murder." The publication of his findings in 2012 led the then Prime Minister, David Cameron, to make an unprecedented apology from this dispatch box to the Finucane family on behalf of the British government, citing the, and I quote, "shocking levels of state collusion," end of quote, in this case. In 2019, the Supreme Court found that all the previous investigations had been insufficient to enable the state to discharge its obligations under Article 2 of the European Convention on Human Rights. The court identified a number of deficiencies in the state's compliance with Article 2. In particular, Sir Desmond's review did not have the power to compel the attendance of witnesses. Those who met Sir Desmond were not subject to testing as to the accuracy of their evidence, and a potentially critical witness was excused from attendance. In November 2020, the then Secretary of State for Northern Ireland announced that he would not be establishing a public inquiry at that time, pending the outcome of continuing investigations. But that decision was quashed by the Northern Ireland High Court in December 2022. Mr. Speaker, this government takes its human rights obligations and its responsibilities to victims and survivors of the Troubles extremely seriously. And the plain fact is that 2 decades on, the commitment made by the government, first in the agreement with the Irish government and then to this House, to establish an inquiry into the death of Mr Finucane remains unfulfilled. It is for this exceptional reason that I have decided to establish an independent inquiry into the death of Patrick Finucane under the 2005 Inquiries Act. I have, of course, met Mrs Finucane and her family, first on the 25th of July to hear their views, and again yesterday to inform them of my decision. Mrs Finucane asked the government to set up a public inquiry under the 2005 Act, and as I've just told the House, the government has now agreed to do that in line with both the 2019 Supreme Court ruling and the Court of Appeal judgment in July this year. In making this decision, I have, as is required, considered the likely costs and impact on the public finances. It is the government's expectation that the inquiry will, while doing everything that is required to discharge the state's human rights obligations, avoid unnecessary costs given all the previous reviews and investigations and the large amount of information and material that is already in the public domain. Indeed, in the most recent High Court proceedings, the judge suggested that an inquiry could, and I quote, build on the significant investigative foundations which are already in place. Mr Speaker, as part of my decision-making process, I did also consider whether to refer this case to the Independent Commission for Reconciliation and Information Recovery. The Commission has powers comparable to those provided by the Inquiries Act to compel witnesses and to secure the disclosure of relevant documents by state bodies, powers identified by the Supreme Court as being crucial for the government to discharge its human rights obligations. The Commission was found in separate proceedings in February this year by the High Court to be sufficiently independent and capable of conducting Article 2 compliant investigations. And while I am committed to considering measures to further strengthen the Commission, I have every confidence in its ability under the leadership of Sir Declan Morgan to find answers for survivors and families. However, given the unique circumstances of this case and the solemn commitment made by the government in 2001 and again in 2004, the only appropriate way forward is to establish a public inquiry. Mr Speaker, many of us in this House remember the savage brutality of the Troubles, a truly terrible time in our history, and we must never forget that most of the deaths and injuries were the responsibility of paramilitaries, including the Ulster Defence Association, the Provisional IRA and others. And we should also always pay tribute to the work during that time of the armed forces, the police, the security services, the vast majority of whom served with distinction and honour, and so many of whom sacrificed their lives in protecting others. It is very hard for any of us to understand fully the trauma of those who lost loved ones, sons and daughters, spouses and partners, fathers and mothers, and what they have been through. And there is, of course, nothing that any of us can do to bring them back or to erase the deep pain that was caused. But what we can do is to seek transparency, to help provide answers to families, and to work together for a better future for Northern Ireland, which has made so much progress since these terrible events. I hope that this inquiry will finally provide the information that the Finucane family has sought for so long. The government will seek to appoint a chair of the inquiry and establish its terms of reference as soon as possible, and I will update the House further. Mr Speaker, I commend this statement to the House.
Right, we come to the Shadow Secretary of State, Alex Burke.
Thank you very much, Mr Speaker, and thank you to the Secretary of State for his statement and for advance sight of this statement and for the courtesy call that he made me this morning. I'm particularly grateful to him for bringing this statement forward before recess. I know that the deadline that the court gave him was the 27th of September, and so it was very important that we had a chance to hear the government's position and ask questions before we rose for conference recess. The murder of Patrick Finucane, like so many murders during the Troubles, was a dreadful act of violence which must not be forgotten. The opposition stands by the findings of the 2012 De Silva report that whilst there was no evidence of an overarching state conspiracy in the case of his murder, there were shocking levels of collusion, something for which the then Prime Minister, now Lord Cameron, rightly apologised to the House in that year. I fully appreciate the Secretary of State's desire to bring this matter to a close after a very long period, and I know that a full public inquiry will do it. But I do wish to ask questions, serious questions, about the decision to choose a full public inquiry over one of the alternatives that he mentioned. It is clear that the Finucane family, who have suffered so much, are owed a further and deeper investigation. And that much was made clear by the Supreme Court's finding in February in 2019, when the court noted that the De Silva report had not been able to compel witnesses or take its evidence in public. In other words, it had not been Article 2 compliant. But as the Secretary of State said, this year the Belfast High Court concluded that the Independent Commission for Reconciliation and Information Recovery, the ICRIR, was capable of conducting such an investigation which was Article 2 compliant and was sufficiently independent to do so. So my first question to him this afternoon is that given that the ICRIR has powers to compel witnesses and take evidence in public, what is it that a full public inquiry will be able to do that the ICRIR cannot? This is important because the ICRIR is already fully staffed and active. It could begin work quickly, whereas the establishment of a full public inquiry, the building of that team, will inevitably take time. So given the opportunity for further delay, can I ask him to set out for the House what steps he is taking to ensure that this public inquiry is conducted as quickly as possible? Can he give an undertaking to have appointed a chair and agreed terms of reference before the end of the year, say? I noted in his statement that he referred to the High Court proceedings where the judge suggested that an inquiry could build on the significant investigative foundations which are already in place. I hope that will mean that we can have terms of reference relatively fast. Similarly, in his conversations with his Right Honourable friend the Chancellor, has he set an expectation of time and costs? We know from previous public inquiries that unless these things are considered early on, the inquiries can take a long time and cost a great deal. On the issue of the ICRI itself, I've been very pleased to hear that the Commission has his confidence. We agree that it's showing itself to be an excellent and effective body with a highly capable chair. I would note that it was also the creation of the previous government, created, as he will know, by the Legacy and Reconciliation Act, which his government has committed to repeal. Indeed, the House will want to appreciate that a very large part of that legislation is given over to the creation of the ICRI. So can I ask him to reassure us that he has no intention of repealing that part of the Legacy and Reconciliation Act? Returning to the public inquiry that's just been announced, I think there's one other issue on which we should seek clarity today. He referred in his statement to the unique circumstances of this case. I think it's very important that we understand exactly what those unique circumstances are. This is because, Madam Deputy Speaker, it's very important that the government does not unwittingly set a precedent for many more public inquiries. I'm a veteran of the Cabinet Office, and whilst I was there, I became acutely aware that there's a danger that public inquiries could cease to be the exception and become the rule. Given that there are thought to be thousands of murders from the Troubles still unsolved, there is a risk, I think, of setting a precedent that would make inquiries the rule, because there will be those who say if there is to be a full public inquiry in one murder case, why not in another? Why not indeed in many others? To avoid that happening, if this case is, as he says, genuinely unique, the government, I think, has a responsibility to set out why it is. We must not risk turning the system of public inquiries into a more routine process. I'm sure that the Honourable Gentleman, Right Honourable Gentleman, will feel the same way, and I ask him to make that commitment. I thank him for a statement.
Okay.
Well, I'm very grateful to the opposition spokesperson for his opening remarks. And can I respond directly to the very legitimate questions that he has put? What is unique about this case, and I apologise for the length of the opening statement, but I thought it was really important to take the House through the history. What is unique about it is the commitment given on 2 previous occasions by the government of our country that there would be a public inquiry. And it sets no precedent, to come to his last question. It sets no precedent, but there were exceptional circumstances relating to this case which has led me to take this decision. I will, of course, especially as the Finucane family have been waiting 35 years, seek to establish the inquiry as quickly as possible, have to appoint, of course, a judge. The judge then has to be consulted by myself about the terms of reference. The time it will take will depend on how the inquiry unfolds. I am acutely conscious of cost, and the Honourable Gentleman makes an extremely fair point, which is why it seems to me, given all the material and information that's already out there, what the inquiry can most usefully do is not seek to go over all of that, but to interrogate the information and the material and witnesses as necessary, because that is, as the Supreme Court made clear, what has been missing that led them to conclude that this was not Article 2 compliant. Look, we have a commitment to repeal and replace the Legacy Act, and we will be beginning that process shortly in finally laying to rest the conditional immunity. The Honourable Gentleman would have heard what the government has said about civil cases and inquests. On the Independent Commission, I've been very clear when I was in this role in opposition and since taking up the office of Secretary of State that while we want to return to the principles of the Stormont House Agreement, that said, there needs to be information recovery, there needs to be continuing investigation. It's true, envisage 2 separate bodies. Those functions are combined in ICRA. And I've been very frank in saying I don't see the point. Now it's been established, all the staff appointed, I really don't see the point in abolishing it, only to recreate something that looks very much like what we have today. So it's a pragmatic decision that I've taken. Now, I also made clear in my statement that I am committed to considering further steps to strengthen its independence and its powers as necessary. I hope that provides the Honourable Gentleman with the reassurance he was looking for.
Colum Eastwood.
Madam Deputy Speaker, on the 17th of January 1989, Conservative Minister Douglas Hogg claimed in Parliament that solicitors in Northern Ireland were unduly sympathetic to the cause of the IRA. MP Seamus Mallon responded that he had no doubt that there are lawyers walking in the streets or driving the roads of the north of Ireland who have become targets for assassins' bullets as a result of that statement that has just been made tonight. 3 weeks later, lawyer Pat Finucane was shot 14 times and murdered in his own house in front of his wife and 3 children. Can I commend Geraldine Finucane and the Finucane family, including, of course, the member for North Belfast, for the tireless campaigning that they've done to get to this point. And can I thank the Secretary of State for finally doing the right thing on behalf of the British Government and announcing this inquiry. Can I ask him, when does he envisage this inquiry beginning?
Secretary of State.
Well, can I thank the Honourable Gentleman for his words. I mean, he alludes to a very, very unhappy history in this and many, many other cases, because I do take the point that the honourable member who just questioned me said about all of the pain and suffering that all families have experienced. But because of this particular case, I've decided this is the right thing to do, and I'm grateful to the honourable member for his appreciation.
James MacCleary.
Deputy Speaker, thank you, Secretary of State. The murder of Patrick Finucane remains a shocking crime, even now, 35 years on, and even in the context of so many tragedies that took place during the Troubles. in Northern Ireland. I'm sure everyone in the House, like me's thoughts are with the family of Patrick Finucane, who have suffered for so long waiting for answers after that terrible day. And I hope that the independent inquiry announced by the Secretary of State will go some way to bringing some closure, at least, for the family after all these decades. The Liberal Democrats welcome the Secretary of State's statement and the announcement of the independent inquiry. But I'd like to ask the Secretary of State whether he agrees with me that there is a need to acknowledge the wider need for truth and justice in Northern Ireland, in contrast to the Honourable Member, the Shadow Secretary of State. I'd like to ask if he would come to the House with a wider statement on repealing the Legacy and Reconciliation Act that, of course, the Liberal Democrats opposed in the last Parliament, and talk more widely about the role of legacy in Northern Ireland, which is, of course, so important. I'd also, Madam Deputy Speaker, can I ask the Secretary of State for clarification on the ability of this inquiry to compel documents and witnesses, and, like others, ask about the timescales of the inquiry, which I'm sure he will agree that Patrick Finucane's family have waited long enough already.
State.
Well, I'm very grateful to the honourable gentleman for his welcome for the inquiry, and I'm very happy to give him and all members of the House an assurance that as we develop our proposals, I'm in the process of talking to lots of people about how to give effect to the repeal and replace commitment that there was in the King's the gracious speech, and I will, of course, come back to the House with proposals in due course and keep the House informed. The honest answer to the question he has put and other members have put is I want to get on with this as soon as possible, but I have certain duties I have to undertake in order to give effect to it. But after this long period of time, let's get going with this as soon as we possibly can.
Claire Hanna.
The brutal murder of Pat Finucane in front of his wife and children was mired in collusion before that killing and in the many long years since. Today is about the tenacity of the Finucane family, including my constituency neighbour John Finucane, but it will have resonance for many other victims of the Troubles whose needs have for many years been put behind the needs of the victim makers who want the truth to remain covered up, and I'm so glad that the truth may now finally out for this family. The Secretary of State will know that many other families have faced obstruction from state and non-state actors in their quest for truth and a reconciled future. I'm thinking of families like those victims of Freddie Scappaticci, like the family of Sean Brown and many, many others. Will the Secretary of State now commit to the same swiftness and determination to removing the barriers that are placed in front of those families in their quest for truth?
State.
Well, I would say to the honourable member that each case, and she alludes to some of them, and we are, of course, awaiting the final report of Operation Canova, the interim report having been published early this year. I undertake and make a commitment, as any holder of this office would do, to carefully consider each individual case and reach what I think is a sensible way forward. But we have a huge task, all of us, collectively, to play our part in enabling families to find out answers that they haven't yet had. And in that context, I have to say I welcome the announcement by ICRA on Monday of this week that they'd had 85 inquiries and have already agreed to start looking into 8 cases. And I think that is significant, because there are those who say no one should go anywhere near ICRA because of its origins and parentage, if I may use that phrase. But having taken the decision that it will remain in place, it does have powers, it does have the ability to get information, it does have the ability to question people. It has said that it wants to develop a system of they call enhanced inquisitorial procedure, which is public hearings. And of course, hearings in public are really important to many families because they want the truth to come out, to be able to question, but crucially, for justice to be seen to be done.
Julian Smith.
Can I press the Secretary of State further on this issue of other families? Months ago, they saw, with the previous government, a bill, which I did not support, repressing and restricting their ability to have inquests in that bill. Today, they now see a full public inquiry for another family. Could he update the House on what personal engagement he will do. Because I think inevitably those families are going to say, we've got a public inquiry here, and then we're being asked to wait in the queue on this legacy bill inquest body, and they will think there is something that isn't right about that.
Secretary of State.
I'm very grateful to the Right Honourable Gentleman who was such a distinguished holder of this office for raising that point. I have met in the past 3 weeks a number of those families whose inquests were brought to an end, both because of the May the 1st portcullis that came down that brought an end to the inquest, and others because the coroners had said, we don't think we can take this any further because of issues to do with confidential material. And I undertake to the House to reach a decision in those cases and to inform the families as quickly as possible. One of the reasons why we made the commitment in relation to the Legacy Act is, and I've said this before, what is it about this part of our United Kingdom that citizens should be denied the right to bring a civil case, which is what the Act did, denied the right to have an inquest? That cannot be right and proper, and that's why this government has made that commitment.
Adam Jogi.
Madam Deputy Speaker, and I welcome the Secretary of State's statement today, and I'm sure all colleagues give thanks that Northern Ireland and its people now live in peace. Can the Secretary of State tell us how he thinks this announcement today will help contribute to the continued and meaningful reconciliation in Northern Ireland?
Well, for one family, it now provides a process. But look, I am very, very conscious that there are many other families who will say, what about us? What about us? And that is why we need to find the most effective means in order to get to the truth. And that is part of the reason, as I've already explained, why I decided that we would not get rid of the Commission. And I have met Sir Declan Morgan a number of times, and I have confidence in his ability to do his work. And we have to find practical means of providing answers to all of those families so that they feel that their story can be told and they can get what they have been looking for. The point I wish to emphasise again to the House today is this particular case is exceptional for the reasons that I set out in my statement.
Gavin Robinson.
Thank you very much, Madam Deputy Speaker. One of the things the Secretary of State did not outline in his statement was that the Supreme Court considered whether it was appropriate not to proceed with a public inquiry, and the Supreme Court agreed, provided an investigation could satisfy Article 2 compliance. And he has said today that the ICRIR not only has his trust and confidence, but has the ability to perform such tasks for other families. So when he rightly says families across Northern Ireland will ask the question, what about us? So too do I. Because the most exceptional circumstance around this is the exceptionality of treatment. Over 1,200 families still have neither truth nor justice. And if the plans that were enacted last year continue, then they will never get justice. But I would ask him, in repudiating the ICRIR, in suggesting today that it is not an appropriate mechanism for the Finucane family, and I do not besmirch their grief or their quest for truth and justice, but it is appropriate for every other. How can he honestly look victims in the eye and say that there isn't a hierarchy?
Well, there should not be a hierarchy, and the Right Honourable Gentleman and I both shared reservations, indeed opposition, to the Legacy Act, because it did cut off lots of routes to justice. And in the end, I think families should have the opportunity to avail themselves of inquests and civil cases. The Commission is now in existence. The honest answer to his question is that in this particular case, and that doesn't apply to any of the others, the government of our country made a commitment twice. once at Weston Park, and secondly by the then Secretary of State, made a commitment to establish a public inquiry. And I think it's right and proper, a government in the past having made that commitment, that we honour it, and that is the answer I would give him.
Richard Bergen.
Thank you, Madam Deputy Speaker. The state's collusion in the murder of a human rights lawyer in front of his wife and children, what an incredibly serious matter which chills us all. So I very much welcome the decision by my honourable friend, the Secretary of State for Northern Ireland, for a public inquiry into the murder of Pat Finucane. It's a decision to be welcomed. It's a good signal from our new government that it's meeting its commitments and obligations. But of course, this very welcome announcement must be followed by the action that the Secretary of State has rightly outlined. So can my right honourable friend, the Secretary of State, give further reassurance to this House that all necessary resources will be provided so that there can be truth and justice in this incredibly important matter?
Well, I'm grateful to my honourable friend and neighbour for what he has just said. Look, having made this decision, I think all of us would recognise the need to get on with it as swiftly as possible.
Sammy Wilson.
Madam Deputy Speaker, this is a bad decision today. It will cause anger and further hurt for the many hundreds of families who have not had justice for the murder of their loved ones, including the mass murder of Protestant workmen at King's Mills, the blowing up of Protestant workmen at T-Ban, and the horrendous murder of worshippers at Tullyvallen, amongst others. And I think that the Secretary of State has to explain to the House why, after tens of millions of pounds have been spent on inquiries and reviews of this case, he still believes that it is necessary to acquiesce to the demands of the family in having another inquiry. And how does he justify to the hundreds of families that there will be no such resources placed in seeking out the truth about the murders of their family members? And given the record of inquiries of this nature being golden goose for barristers and solicitors in Northern Ireland, how is he going to ensure that the costs are capped?
Well, the first thing I would say to the honourable member, and as he recounts some of the terrible murders, and I have myself met the only survivor, as I'm sure other members have, of the King's Mill massacre, and heard firsthand the truly chilling story of what happened on that day. I would say, first of all, considerable resources are now being given to the Independent Commission. And it's important to recognise that, because it has a huge task on its hands. I hope that others will come forward to the Commission to avail themselves of what it can offer. That is the first point I would make. The second is, and I have said it to other members in answering their questions, in this particular case, there was a commitment that was made twice. And I think it's important that we honour it. And we also have to recognise, in this particular case, the court found that all of the investigations, and I accept what he said about them and the extent, and of course they involved the expenditure of public monies, the court held in 2019 that did not meet the requirements of Article 2. And faced with that, faced with the quashing at the end of 2022 of the decision of a previous Secretary of State not to call an inquiry pending further investigations, it has fallen to me to look at this and to decide how we're going to go forward, and I've set out my reasons as clearly as I can hope to do.
Thank you, Madam Deputy Speaker. Can I clarify from the Secretary of State that he has now ended any opportunity from those families, those loved ones who still held out a hope for an inquiry into the death and the murder of their loved ones at the hands of terrorists, across Northern Ireland. And he is now saying today that the only opportunity for them is to go to the Independent Commission for Reconciliation and Information Recovery, an organisation that doesn't have the full support of the communities of Northern Ireland and doesn't have the support and is queried under many of the families who have lost loved ones. Can I just seek clarity from the Secretary of State that he is saying to those families that their only opportunity for truth, recovery and justice is to go through this organisation, and he will not engage with them in regards to a further inquiry?
Secretary of State.
Well, I would say to the honourable gentleman that it should not be the only opportunity open to them, the Independent Commission. And that is why I've already indicated that this government will restore civil cases, and we will restore inquests in the first instance in those cases where they've been brought to an end by the Legacy Act. Because I agree with him, it would be quite wrong if one was to say there's only one route, denying people, families, the rights to inquests and civil cases that apply in all other parts of the United Kingdom. That was one of the things about the Legacy Act that was so profoundly wrong. It said, not we're going to establish a new body and you can use that route, but you also have the other two inquest and civil cases that have been available to you thus far. It shut those down. That's part of the reason why the Legacy Act was so widely opposed in Northern Ireland. Now, I must be honest that it will take time, obviously, because it will require primary legislation to deal with that bit of the Legacy Act that stopped the inquests and the civil cases, and that will flow from the consultation that I'm currently undertaking.
Jeremy Corbyn.
Thank you, Madam Deputy Speaker. Could I thank the Secretary of State for the statement today? And I think we should all put on record our thanks to the member for Belfast North and his mother Geraldine and all of the Finucane family that have campaigned for so long, and so many others, for this inquiry to take place. I recognise the difficulties in prescribing what an inquiry should do, the cost of it and the length of time it would take. But is the Secretary of State in a position to tell us roughly when he would expect to establish the inquiry in its formal setting? And is he able to put some kind of outline timetable on it as to how long it should take to bring about, hopefully, a resolution to the disgraceful murder of Pat Finucane all those years ago?
Secretary of State.
I'm grateful to the right honourable gentleman. As I've already indicated, I will seek to establish the inquiry as quickly as possible. How long it will take is ultimately in the hands of the judge when he or she is appointed.
Hanna.
Thank you, Madam Deputy Speaker. Can I thank the Secretary of State for the statement today? As the Secretary of State understands, the Democratic Unionist Party stood against the legacy legislation in the interest of pursuing justice for victims. This indication today will give hope for families such as Kingsmill as an example. I had a debate in the Kingsmill massacre in a German debate in the last term of Parliament. On the 5th of January 1976, 48 years ago, 10 innocent men who just happened to be Protestants were murdered with weapons linked to 40 other serious Republican terrorist crimes over a 15-year period, and which indicated information was withheld by the Garda Síochána. Quite clearly, some of the Garda Síochána, Madam Deputy Speaker, had IRA sympathies, and it could be said that they were agents of the Republic of Ireland state by their very position. Secretary of State, will the families of those 10 innocent Protestant men be granted the same path to justice as the Finucane family? If there is no inquiry granted to Kingsmill, then it will be perceived, and indeed proven by the Secretary of State himself, that there is a two-tier state of justice of victims that has been clearly enshrined by this very government. How disappointing, how disgusting, and how angry that makes me.
State.
Well, I'm sorry to have disappointed the honourable member, and I've already indicated that, having met the one survivor of the Kingsmill massacre, I have some appreciation of just what an appalling and brutal event that was at a time of many appalling and brutal murders. There has been an inquest which concluded recently and, as I recall, held the Provisional IRA responsible for that murder. If, and I'm sure the families want to proceed further, one of the options open to them is to go to the Independent Commission. But at the risk of repeating myself, I do need to point out that I have come to this conclusion because this particular case, the Finucane case, is exceptional for the reasons that I have tried to explain.
Minister.
Speaker, could I begin by apologising to the Secretary of State and the House for being absent at the beginning of his statement? Secretary of State, has there ever been a family given more preferential handling by government than the Finucane family? Prime Ministerial apology, multiple investigations, inquiries, and now a uncapped public inquiry, after that family had rejected previous government offers of inquiries. Isn't the takeaway, the tragic takeaway from the Secretary of State's statement today, that for innocent victims of the IRA, UVF and others, the ICIR is good enough for them, but it's not good enough for the Finucane family? Why is the Secretary of State perpetuating that odious hierarchy of victims?
State.
Well, I am not, is the answer. And I know that the honourable member was slightly late in coming into the chamber, and from the beginning, I set out my thought process, and he will have an opportunity to read my statement subsequently. The reasons why I've reached this decision were clearly set out by me. It is a fact that when the then Prime Minister, David Cameron, apologised from this dispatch box, it was unprecedented. It was, because he referred to shocking collusion in this case. And we should take that extremely seriously as members of this House, all of us who are committed to upholding our obligations, and faced with the circumstances of two promises to establish public inquiries. And I accept what he says about why it didn't happen after 2004, because of the stance that the Finucane family then took, which has now changed, but also because of the decision of the Supreme Court in 2019 that said, for all that has gone before, I'm afraid the state has not complied with its Article 2 obligations. We will now be doing so.
Thank you so much. That concludes that. I'll give the front benches a moment to change over.